Johnstone. Thank you.
Good morning, Your Honors. I'm Attorney Patricia Johnstone, and I'm here on behalf of Kristen Bedell, the appellant. First, I'd like to address the primary question of whether we should even be at this court. One of the questions that, given the procedural difficulties with this case, at the lower court level, and I know both my sister and I have investigated this, there is absolutely no case law on this particular issue, on the fact that the judge on the trial level took, and in lieu of giving an evidentiary hearing or a trial on the divorce, effectuated a property division by virtue of releasing the automatic asset restraining order. Immediately from that, I did take an appeal under 231, Section 118, an interlocutory appeal, and unfortunately, Mr. Bedell died shortly thereafter.
Why couldn't you then take final judgment entered, correct?
Final judgment, a judgment of dismissal entered, Your Honor.
Well, that's final judgment, correct? Why couldn't you take an appeal from that?
At that point, Your Honor, I had already gone before the, filed my interlocutory appeal, and they had asked for supplemental briefs on the issue of Mr. Bedell's passing away and whether they had jurisdiction, because there was no open case.
No, I understand that, but so you went into the appeals court on an interlocutory basis, because at the time it was an interlocutory basis, correct? And then, because of tragic circumstances, the husband passed away. Case law was clear. I mean, the law is clear that when party to ongoing divorce proceedings is deceased, the divorce proceeding is dismissed, correct?
It's abated, Your Honor.
But that's a final judgment, correct?
The abatement automatically closed the case, as you noted on
Yes.
Judge Cronin's.
Yes, so the case is finished, right?
Correct, Your Honor.
And then one can appeal from any issues. It's a final judgment, and one can appeal from any issues in connection with that case.
In the normal procedure, that would be correct. In this
We've got a
procedure,
case that
because
says that's what you do in this proceeding.
the case,
I mean,
you're
it's
referring to Diggs v. Diggs, Your Honor?
no, Edinburgh
Edinburgh.
is-
Edinburgh, on that case, Your Honor, they had predeceased before, and the court had entered a non-protunct judgment backwards, if that's the case, if I'm remembering this correctly. The legal fees in that case, which were still open, were
Right.
the result of a contempt judgment, Your Honor.
Right.
That had been ordered before the decedent had passed away.
Right.
In this case,
There was an order that you were challenging that had entered before the decedent passed away.
a temporary order, Your Honor, not
Yes,
not a,
it was an order that entered.
correct.
And
And
you challenged it,
and I challenged it.
and you could have challenged it again. Why couldn't you challenge it again?
To me, I believe that would have been a baseless argument to make, since I'd already been told by the appeals court that the case had abated and they had no jurisdiction because there was no open case.
But that was in the appeals court, right? So the case now goes back. When did you have that conversation?
I had that conversation on March 19th. March,
With a clerk?
With the clerk?
yes. I had the conversation with the clerk after the court had already denied on exhausting my administrative remedies. And I was told that I could no longer, I had no right of appeal up to the appeals court since
No,
there was no open case.
The clerk got it wrong.
The Justice Kafker had denied my appeal. I
Your
filed
interlocutory appeal.
my interlocutory appeal.
That was before, that was on the same day, correct, as the decedent passed away, correct?
Pretty close, Your Honor, yes.
So that's interlocutory,
Correct,
right? Then the decedent passes away.
correct.
And then the law says certain things happen when a party to a divorce proceeding passes away, correct? Namely, the case is dismissed, abated, or whatever, final judgment. That is a final judgment. The proceedings are terminated, correct?
Yes, Your Honor.
Then you can take an appeal to the appeals court about anything. It might be an award of attorney's fees. It could be that this was an unfair order. There was nothing to stop you from doing that at that time.
At that time, I'd already been turned down twice, Your Honor.
Doesn't
And
matter.
based on that it
Doesn't
was,
matter.
Well, I guess the point is, we're getting at is the clerk gave you bad advice, and you should have just plowed ahead and filed a notice of appeal, and the clerk would have to accept that, assemble the record and so forth, and then eventually a panel of the court would have had to decide whether this order remained extant or didn't remain extant, or whether the abatement should lead to your appeal being dismissed or something like that. The whole point being there was an available remedy that doesn't get you here under superintendents.
I understand that, Your
A
Honor.
little tricky,
And I
but-
did appeal the single justice's denial, Judge Kaffner's. I did file an appeal asking for a full panel, and that too was denied, saying that the court didn't have, under that action, that it was inappropriate.
Is it docketed?
Yes, Your Honor.
Yeah, but at that time, the court didn't.
On April 23rd.
The court didn't, because that was an interlocutory order. It was not a regular appeal. There's a regular appeal process that starts when final judgment is entered in a case. Before final judgment is entered, there are all kinds of orders that are appealed. They're interlocutory orders, and sometimes they are granted, sometimes they're not, and sometimes you have a right to appeal them, and sometimes you don't. That's all interlocutory. Then there's just the appeal from a final judgment or anything that occurred in connection therewith.
So even though there was no open case, and the appeals court had already...
Because you hadn't opened it. You didn't open it.
The divorce had been closed, so I had no open case.
The divorce had been closed in the probate and family court. That's
And-
what happens when, that's how you get a normal appeal. Something finishes. As a general matter, the appellate courts cannot get involved while a case is pending in a trial court. There are limited circumstances, and they are called interlocutory appeals. But once the case is finished, then the rules of civil procedure provide that you can then commence an appeal in the appellate court.
But when we went before the appeals court, and my sister advised them that Mr. Bedell had passed away, the appeals court asked for supplemental briefs on that specific issue, on whether they would then continue to have jurisdiction on the case. We submitted those supplemental affidavits arguing this point. I also had filed the motion to stay in the probate court, and Judge Cronin at that time made the notation on his ruling, after he had been informed that Mr. Bedell had passed away, that he didn't even believe that he had to make any ruling on that because no further action could be taken at that point. And I did investigate and go forward and ask if I could have filed the appeal in the appeals court, and was told, no, I could not, that my only source of relief was to come to this court.
Did you try to file a notice of appeal?
From the judgment of dismissal of the contempt?
Any issues in connection with that final judgment?
The judgment of dismissal, is that the final judgment, Your Honor? No. I had filed the motion to vacate the judgment of dismissal, and I filed the petition here.
Okay.
And then going towards the merits of the claim, Your Honor, at the time of the hearing, I had been out of the country and returned back to find the motion on my desk. At that point, I went to court, and I had asked, as the record reflects, many times for a couple days to brief it, because I believe it was beyond the court's jurisdiction at that time, that to so go forward on it was to defeat my client's right to a trial to present evidence. At that hearing, there was no evidence presented. The parties were not there. It was just counsel, as the record reflects. And I pointed out as I went forward that even the pretrial, which was presented by previous counsel, at that point, discovery had not yet been completed. Both parties had to complete discovery. Valuations hadn't been done. The husband's financial statement put down values of unknown on substantial assets. So when Judge Cordy had made his ruling that the judge had enough evidence before him at the pretrial, I would submit respectfully that that was not an evidentiary hearing. The parties were there, but there was no testimony taken. And the financial statements in the judge's pretrial order afterwards, it makes it very clear that there was no evidence presented at either of the hearings.
What is the financial impact on your client of this order?
It actually impacted my client substantially, Your Honor, because of the pension was transferred and 1/3 interest in a mortgage-free real estate. It was the impact of about $200,000, Your Honor.
And in terms of the overall estate, what percentage is that?
It was about a 70-30 division in favor of Mr. Bedell. And that didn't include offsets that had been argued about pre-existing withdrawals, and none of the debt was taken into consideration or even discussed.
Thank you, Ms. Johnston.
Thank you, Your Honors.
Ms. Harrington?
Morning, Your Honors. I'm Mary Harrington, representing Scott Bedell and Wendy Fareed. Your Honor, I start with the threshold requirement that I don't believe that Ms. Bedell has met, and that they have no proof of the absence of an adequate alternative remedy. Your recent decision in McMenamin and Passatempo reinforces the standard that 211.3 is clearly an extraordinary remedy. It also discusses...
Excuse me for interrupting you. Could I ask you this question? The issue that was decided by the... I take it from what Ms. Johnston just said, that something happened in the appeals court after final judgment had entered in the probate and family court.
I don't believe that's what she said, and that isn't what happened.
So I'm confused.
My understanding...
So that there were some issues around the interlocutory appeal,
Right.
taking the order, whether you had a right to appeal it, and so on and so forth. Somebody told the appeals court, that the husband had passed away, but final judgment had not entered.
That's correct.
And then final judgment entered, and there were no further proceedings in the appeals court.
There were not.
Okay.
No, that final judgment didn't enter until later in April.
April of 2000.
Well, your point is fairly simple. There was a final judgment which could have been appealed from in the normal course, and a panel could have gotten into the issue of whether this interlocutory order was proper or not. If it was improper, the estate could be ordered to return the
Right.
money
Or
or whatever.
That's clearly one avenue. I also think another avenue was that upon his death, similarly, a traditional immediate appeal to the full bench. When counsel was...
How could you couldn't do that until final judgment?
Well, I think the better case is at final judgment, but I thought Edinburgh read that upon death, any interlocutory orders become final, and you could have appealed at that point as well to the full bench. But obviously, that I think is more questionable, but clearly upon the dismissal of the case, which happened. And if you read through the colloquy that day when we went in on the motion to vacate the dismissal filed by counsel.
Before whom? In the probate and family court?
Before Judge Cronin in the probate court. After he entered a judgment of dismissal based on my suggestion of death and request for dismissal. Counsel for Ms. Bedell filed a motion to vacate that dismissal.
Right.
When we argued that, and that colloquy is in here, Judge Cronin said, isn't it better for you if the case is dismissed? It gives you an ability to go forward, in so many words. And it was pretty clear, I thought then, that's what should have been appealed from at that point. I also think there's a third avenue, and I had raised it before Justice, in the single justice brief that I presented, and in fact, it's in the appendix on pages 293 to 295. Justice Cordy made short shrift of it, and I didn't raise it again in the brief to the full bench. You do have it before you, and I do think that the argument that they could have done or should have done a 221 appeal from the appeals court second when the second single justice dismissed that. And the case is DiBiase.
If you haven't raised it, why is it not waived?
I'm sorry?
If you haven't raised it, why haven't you waived it?
Well, I had raised it in the single justice
I understand.
brief, and it is in the appendix that you have in this
But, Ms.
case.
Harrington, isn't that trying to have it both ways? I mean, if it is if it became final upon the death of Mr. Bedell, how could we have an why is it an interlocutory order that's being appealed from under Rule 221?
I think it is a third avenue that was available at that point.
So you're saying Rule 221 applies to the appeals court?
According to DiBiase versus DiBiase, which is at 423 Mass 1003, that case was an appeal under 221 to this court from a single justice of the appeals court. I haven't found that that was ever overturned. And so if there's, it just seems to me it just adds one more layer that this party had.
But I'm not familiar with that case. But a single justice of this court must have been involved, correct?
It must have been a
There must have been
211-3 from...
211-3, something.
Yes, from a denial by a single justice of this
Yes,
court
so
of a
if they-
petition for relief under 211-3.
Well, there you go. So 221 comes into effect.
But that's it has to be an interlocutory order.
But the court there said because this denial concerned an underlying interlocutory order.
Underlying interlocutory
Right,
order.
right.
But
That was on that was when they were at the appeals court.
But once final judgment is entered in the trial court,
I think there's absolutely no question, and that's clearly the best avenue and the one I should be focusing on. And so I agree that I think when the case was dismissed in the probate court, the traditional appeal to the full appeals court is what should have happened at that point. And any discussion counsel had with the appeals court clerk was prior to that judgment of dismissal entering.
it was?
Yes.
Because Mr. Bedell died on March 20th, correct?
And the discussions that counsel had were around the time of the denial of the interlocutory and those two single justice. That's when the conversation was with the clerk. There was never a discussion with the clerk, as far as I know, and has not been represented, of the appeals court after the judgment of dismissal in the probate court,
So
which
the
is
clerk,
when.
in your view, in your factual knowledge of the case, the clerk did not screw up.
No, I don't know if the clerk screwed up in any information, because I wasn't party to any of the conversations. All I have is the affidavit that counsel has submitted as part of the appendix. All of that was before the judgment of dismissal in the probate court.
But if what you're saying is true, the clerk did not screw up, because at that point, the interlocutory order, the only way you could review it was to go on a 231-118, which was done.
But there were issues, take it after he, just going on what Ms. Johnson said, there was a point in which the appeals court asked you to brief the effect of Mr. Bedell's death on its jurisdiction.
That was the 231-118 appeal, the single justice.
Okay.
That's the only time we briefed at the appeals court. It was the 231-118. It had been filed by counsel. Mr. Bedell died before I had filed a response. They said, okay, you brief both issues, and we're going to request that Ms. Johnstone brief now the effect of the death. That was the two.
Okay.
I'm sorry, I've drawn a blank on the number, but the single justice appeal in the appeals court.
231-118.
After that was denied, Attorney Johnstone filed an appeal of that order to the appeals court, which properly denied it under, is it Caritas?
It was the notice of appeal was stricken, I think.
Right.
Yeah.
Right, which I think was correct, because there isn't an appeal from that single. Thereafter, I file a suggestion of death and a request for dismissal in the probate court.
Right.
On the merits, do you want to just quickly
do.
say your view on the merits?
I do. In my opinion, there was no abuse of discretion. And on page 25 of counsel's brief, they say to you, the appellant is without any remedy to undo the harm of the probate court's order. That harm is the trampling on her rights to a trial on her divorce case pursuant to General Laws 208, Section 34. She doesn't want a trial. She doesn't want an evidentiary hearing, and there can't be one. You can't undo the, quote, harm that she suggests happened, and you can't do anything about her, quote, rights being trampled because of no hearing. Mr. Bedell is dead. There can be no hearing, and she doesn't want a hearing, and she never wanted a hearing, because the result upon his death was that she would get 100%, except, you know, a half of a third of a piece of real estate that was his mother's. That's it. She'd get everything else if Judge Cronin hadn't done anything in this case. Mr. Bedell would have been left with zero. She doesn't want an evidentiary hearing and never did. Judge Cronin, we have the individual calendar in Essex County. He had had this case before him on at least 2 occasions, had information before him, signed.
So what percentage of the marital estate was transferred out before death?
I have the analysis in my brief using
just
different
a rough
numbers.
figure.
It's very close to 50-50. There are ways to look at it, depending on how you look at the piece of inherited property and what number you put on that in fact would give Ms. Bedell a higher percentage. It depends. You know, there was a dispute about the value, but by the way, discovery had closed in October of 2006. So all of these statements about the judge, we needed more discovery, we need to get valuations, we needed to do this, they couldn't. It had closed. They had not asked for an extension. They had asked to continue the trial. They did not ask to reopen discovery, nor in the 4 months that new counsel had been in the case had a single piece of discovery been requested. No valuation of the real estate had been done. And if you go by sort of the case law.
Point is, no injustice has resulted.
Absolutely not. If anything, this was justice served. And to undo it becomes completely unjust to Mr. Bedell, completely. And if you read their pretrial, they said it should be an approximately 50-50 division. That's what Judge Cronin was trying to do. He had the information before him based on signed financial statements under the penalties of perjury. And by the way,
Your time is up.
I'm sorry.
Time is up. Thank you.
Thank you.
Thank you, Ms. Harrington.
All rise. Hear ye, hear ye.